Good afternoon, everybody. I'm Brian Tully. Thank you for joining us once again for our Wednesday webinars. Today, we're going to be talking about peace of mind. And if you've caught us on social media at all, I've been talking about it as well in regard to our clients and our families and how we can help others with peace of mind. But our webinar on peace of mind, dealing with asset protection and aging and Medicaid, will start in 2 minutes. All right, we're just going to give some time for people to log on, and I'll be right back. All right, everybody, we're going to get started. As I get started, however, I always like to verify that I can be seen and heard, that you were able to see my screen, my PowerPoint there. So if somebody could just let me know yes to all three of those things in the chat box or the Q&A, that'd be great. As we get started, I want to make sure that when I share my screen again, we're going to be all good. All right, very good. Thank you. Thank you. All right, now, again, Brian Tully is my name. I am the founder of Tully Law Group. We are an elder care and estate planning firm based on Long Island. We help folks from New York City all the way out east with offices in Melville, real central, and Riverhead way out east. I've been doing these webinars since the pandemic began. It's been over 3 years that we've been doing these at least once, if not twice or 3 times a month since then. So our website has a whole library of webinars as well as our YouTube channel. So tullyelderlaw.com is the website, tullyelderlaw.com. YouTube is Tully Law Group, and you'd be able to see our past webinars. So today is Peace of Mind as You Age, working with asset protection and with Medicaid. We're going to be really covering the gamut. It's both of these topics are worthy of their own webinars. And again, on our website, tullyelderlaw.com, we have individual webinars with a little more depth on these. But peace of mind is what it's all about these days. So let me share my screen and we'll get started. If you have a question, feel free to put it in the Q&A and I'll get to it at the end of the program. We usually go about 45 minutes and then some questions, so I'd be happy to answer as we move along here. All right, so let me go back to screen sharing. All right, here we are. Good. Now, as we get into this, again, we're going to be covering a lot today. So if you have questions, feel free to get it into the box there and I'll answer them as we move forward. So as we begin this topic, I felt it was important, all right, for us to kind of define. We all know what peace of mind is, and when you Google it, there was like 20 different ways that it can be defined. So I just wanted to run through a couple of those briefly with you. A peace of mind is a feeling of calm. It's a feeling of not being worried. Now, excuse me one second. It's about not being worried. It's also a feeling of being safe or protected. It's a mental state of calmness or tranquility. It's a freedom from worry and it's a freedom from anxiety. And it's not worrying about a particular problem or difficulty. Now, in our field, in our career, we deal with families that are struggling to find that peace of mind. When we deal with aging, when we deal with asset protection, when we deal with medical issues, when we deal with finances, when we deal with children and inheritances and the wellness of our children and what are they going to do with the money, all of that can cause anxiety, can cause worry, can take away our calmness. So part of our job, and one that we thoroughly enjoy and want our families to have, is a peace of mind as they age. Okay, so let's pinpoint a little bit what our clients come to us concerned about. And I will assume and presume that a number of these are going to be hitting you and some members in your family as well. One we hear quite often is, I'm concerned about getting older. I'm concerned about losing mobility, our functionality, our ability to walk and handle our own financial affairs. I'm concerned about losing my memory, concerned about not wanting to lose my home, being concerned about wanting to make sure there's something left over to go to your family as an inheritance, concerned about who's going to make decisions for me if I can't do it myself. Also, not wanting to spend all of your money on medical needs or long-term care costs. That's what the LTC is, long-term care costs as we get older. A lot of clients are also concerned with, how do we pay for care? Yes, of course, we have Medicare as health insurance and a supplemental plan, but that's medical. That's medical care. Those are medical bills. It's not long-term care bills. Very different others, excuse me, other side of the coin there. Other issue we come across quite frequently is, how do I navigate the healthcare system? You know, when it's one-on-one with your doctor in your doctor's office, it's one thing. But if you're in a hospital on a timetable for discharge or not even admitted and you're in a hallway on a gurney, how do you navigate that? How do you know who to listen to and what to listen to? And then rehabilitation centers and unfortunately for some people, nursing facilities. Another point is, who will support me and help my family make the right decisions? A lot of folks, as they enter into the world of elder care, are not don't know where to go. It's the first time that they're entering this realm, and they need somebody to trust. They need a guide. Hundreds of doctors and nurses, administrators, social workers, hospitals have lawyers, nursing homes have lawyers, and you're out there as an individual family on your own. That's where we come in to be that guide, that directive, that navigator as you go through and help you make those right decisions. What resources and referrals are available to me and to my caregivers? If my children are helping me with something, where are they going to turn to get help or to get answers? And ultimately, our clients come to us, this may not be spoken, but they come to us with a concern about and being afraid of aging and ultimately passing away. That's a reality. You know, in my family, in my circle, we've had there's been two folks that have passed on in the last week. Not direct immediate family, but just people that we know and care for. And the reality is that is a difficult time as people age. And to have a helping hand, to have a supportive hand, will mean the world to families going through those things. And we're working on helping our families and our clients work through those issues. So as we go through this list of aging concerns, again, I'm sure some of them strike a nerve for yourself or for a loved one. Now, how do we address these concerns? How do we gain peace of mind? Well, it's about planning ahead. All right. As you may have heard before, the saying, it wasn't raining when Noah built the ark. That's a reality, right? When God instructed Noah to build the ark, he's like, I'm not doing that. There's no rain. There's no clouds. We're not there yet. But he trusted and he had a plan. He planned ahead. So when that crisis occurred in the future, he was all set. All right. And just to give you another little encouragement when it comes to planning and preparing, by failing to prepare, a wise old Benjamin Franklin shared once, by failing to prepare, you are preparing to fail. If you don't prepare, if you don't have your plan, you're not going to have peace of mind. You're not going to have some level of security dealing with all of these unknowns down the road. So do what you can to grasp some level of control and lay out in writing your plan. Work with the right people to lay out the plan. So how exactly do we do that? Well, we are what's called a life care planning law firm. In addition, of course, to our estate planning work and the other work that we help families with, life care planning is a very holistic approach to aging and elder care and planning. Now, what we address is going to be the legal issues, the care issues, and the financial issues. These are three domains that we work within every single day of the week for our clients, all three. And most of those concerns, actually all of those concerns, you can fit into each of these domains. The legal domain as far as protection, the care domain as far as navigating or advocating or resources, the financial domain as to the inheritance or dealing with paying for care. All of those concerns can be addressed in a life care plan as people age. Okay. And interestingly, people normally think of a plan. All right, I'm going to do a will, I'm going to do a power of attorney. That's a legal plan. Or I'm going to sit with my financial advisor and have a financial plan. It's important to realize you can also plan for your care. And that's what we're known for. And that's what we do in a very unique and comprehensive way. Okay. In addressing these domains, all right, each domain, the legal, the financial, and the care, each are going to have a goal that we pursue. Okay. The legal domain has a goal of how do we protect the assets. The financial domain is how do we pay for the care that we might need down the road. And the care domain is how do we help your loved one get the best care possible. Okay. We address these, as I shared. Nearly every single client we sit with, we're dealing with these three domains and pursuing these three goals. But the care is the driver. So let's talk about the care a little bit first. What is the care when we talk about care? So from our perspective, and for the point of today, care is going to be the services and supports to meet your long-term care needs. Okay, so it's long-term care services and supports. So what exactly is long-term care? So long-term care is broken into two. Long-term care is first going to be what's called your activities of daily living. And then it's also going to be your instrumental activities of daily living. If you see activities of daily living, we call them ADLs, and the instrumental activities of daily living, that's the IADLs. The ADLs are going to be the physical. That's why we represent that with the walker. The IADLs, the instrumental ADLs, that's the cognitive, that's the processing. So let me give you a little more specifics on the activities of daily living. They are literally what we do every morning. And if you've ever sat in a consultation with me or had a conversation with me about this, you hear me lay it out. It's what we do every morning, right? We get out of bed, that's called transferring. We walk to the bathroom, we toilet, we bathe, we groom, we dress, and we eat. Those are our functional activities of daily living. If you need assistance, generally with two of these, we are now in the world of long-term care. Now, the instrumental activities of daily living, as I shared, are a little more cognitive, okay? So that's going to be transportation, determining how to transport. Are you driving? Are you catching a bus? Okay. It's the finances, paying your bills. It's shopping, it's housekeeping, it's preparing food, it's laundry, and it's managing your medications. So as you can see, again, a little more cognitive. And sometimes you might see these in your loved one start to decline before you see the functional, and vice versa. And sometimes it's both. But these are what lend itself to the crises that we want to avoid. Okay. Now, recapping. The legal, the financial, and the care domains, we want to protect the assets, we want to get the care paid for, and we want to help our clients and our loved ones get the best care possible. Okay, let's get into the legal side a little bit. So the legal domain, as I just shared again, protect the assets. And how do we do that? There's two primary prongs that we pursue. It's ensuring that we have the proper estate plan and asset protection is in place as well. So in the legal component, we're going to go through these needs and planning objectives of estate planning and asset protection for our clients. Planning your estate, what does that mean? Generally, there's going to be 4 legal documents, and it could be 5 for some folks, where that must be in place. when we're talking about planning your estate. And I'll tell this to every client also, every adult over 18 should have these 4 documents. It's going to be a last will and testament. It's going to be a durable modified power of attorney, healthcare proxy, and a living will. Okay. A will, we've all heard about that. And I had a whole webinar on saying it's more than just a will. You know, your plan is more than a will. It's not just about a will. Although we'll get 10 calls a week saying I need a will, there's much more to it. For example, this durable modified power of attorney, probably the most important document right there. It's where you can pick 1 or 2 people to handle your legal or financial affairs. It's where it needs to be modified. A power of attorney, as New York State releases it, is not substantial enough to assist families dealing with aging, asset protection, income protection, Medicaid benefits, retirement accounts. It has to be a modified power of attorney in order to do that, okay? Healthcare proxy is where you can pick 1 person at a time to talk to doctors and make decisions. And ultimately, the living will is the end of life statement. It shares that if I'm ever in an irreversible or incurable condition, I do not want to have any medical treatments that keep me alive artificially, okay? So planning your estate, we want to make sure we have these 4 documents in place, basically backup decision makers, all right? In case capacity is lost, we've got the appropriate authority vested in a trusted person to help with legal issues, financial issues, healthcare decision-making, and ultimately your estate, okay? Now, on the asset protection side, it's really about one thing. In this day and age, you cannot beat the benefits of an irrevocable trust, okay? And I will readily admit that the word irrevocable is not comfortable to the ears of many of our clients. But as I'll share in the next moment or two, there are many benefits to irrevocable trusts, and irrevocable is not really as irrevocable as it sounds, okay? It is the gold standard when it comes to asset protection. But before I get to those details, people say, all right, well, what is a trust? And what's the difference between revocable and irrevocable? So as we talk about asset protection and how to gain peace of mind in regard to it, let's kind of lay out what a trust is, remove the anxiety as it deals to the word irrevocable, and we'll get into some more details. So a trust is nothing more than a written agreement. It could be, you know, we've seen some trusts 5 pages long. We've seen some trusts 80 pages long. They are written agreements that deal with 3 different segments of your life, okay? So the first segment is, I'm creating this written agreement to govern and manage my assets while I'm alive and healthy. And then the trust will govern and manage my assets if I'm alive but not healthy. And then finally, that trust will govern and manage the assets when I'm ultimately gone, okay? So all it is a written agreement that talks about the use and management of assets during these 3 periods of time in your life. Now, a trust has to have 4 different parts that are integral. The first one is going to be the grantor. That's the creator of the trust. That's the person granting the trust. Most of our clients are going to be the grantors of their trusts. But then we also need wrong way, forgive me. We also need a trustee. That's the manager. And depending on what type of trust you implement, a trustee can be yourself, or the trustee should be a child or some other trusted individual. In an irrevocable trust, you as the grantor cannot be the trustee. We're going to name somebody else to be the trustee of your trust. Why? Because the purpose of an irrevocable trust is asset protection. And what we're trying to do ultimately is build a wall between yourselves and the asset you're trying to protect for your spouse or for your family. And the way we build that wall is by putting in different bricks that build the protection. And having somebody else named as a trustee is one of the ways to do that. A third requirement in building a trust is having a beneficiary. Now, this gets a little complicated because there's often multiple beneficiaries. There can be beneficiaries of what's called the principal. That's what's inside the trust. There can be a beneficiary of the income. There can be a lifetime beneficiary, and there can be what we call a death beneficiary. So there's a lot that goes into this, but working with the right firm that can explain things and reassure you and lay things out will help calm the worry and calm the anxiety as these things get laid out so that we can get that plan and ultimately have that peace. Now, the last part that goes into the trust is going to be the property itself, right? If you've ever seen a trust, there's a last page, it's called a Schedule A, and sometimes it just says $10. That's a symbolic way of saying there's at least $10 in this trust. Sometimes we're putting the house into the trust or financial accounts are going into the trust. All of that gets listed on that Schedule A and it's managed then by the trustee, okay? Now, as I shared briefly a moment ago, there are two types of trusts. There are revocable trusts and there are irrevocable trusts. They are different, they serve different purposes. So what are those purposes? So again, two types, revocable and irrevocable, two purposes. I'm generalizing here, folks. There are many, numerous ways and purposes to create trusts, but generally speaking, we are creating a trust for probate avoidance purposes, or we're creating a trust for asset protection purposes, okay? And trying to, really give you an outline here so it's a little more understandable. The revocable trust serves one purpose, and that is to help that family avoid probate. So the assets that are owned by a revocable trust, and by the way, revocable is one where the grantor can revoke the trust. A revocable trust is where the grantor is the trustee. They have all the access and all of the control over what's inside the trust. That makes it revocable, okay? Now, because it's revocable, its sole purpose is to avoid probate. Now, assets also owned by an irrevocable trust also avoid probate. Why? Because they're not in the grantor's name when they pass away. Rather, it's owned by this trust, okay? Now, so good news, both trusts avoid probate. The benefit and additional benefit of an irrevocable trust is that it also protects your assets. Now, we sit with folks of all ages, and generally speaking, 65 and above should be considering irrevocable trusts. But we don't know which trust is appropriate to recommend because there's a lot of factors. For example, a person's net worth, what assets do they have? A person's age, a person's health, all right? Where do they reside? There's a lot of factors of the person's family dynamics. A lot of factors go into which trust is recommended and which trust is best for the client. Last point here is in the irrevocable trust, as I said momentarily ago, there's full control and there's full access because it's a revocable trust. And because there's full control and full access, the revocable trust cannot protect assets. So as we talk about age and aging and protecting your house or protecting your investments and trying to get that peace of mind as to what the future is going to look like, the revocable trust is not the one for aging purposes when we're looking at asset protection, okay? Now, let's spend some time digging into what an irrevocable asset protection trust looks like, all right? Everybody we sit with gets the same points, all right? So I try to make this as clear as possible. In talking about an asset protection trust, again, typically 65 years of age and older, we're trying to protect assets so that as we age, we're able to become eligible for what's called Medicaid, which I'll talk about shortly. And the assets that we put into an irrevocable trust will not be counted against us if we're applying for Medicaid itself. Okay, so that's the context of an irrevocable asset protection trust. And whenever we're talking about asset protection in the context of Medicaid, we have to be aware of what's called a look-back period. Okay, now, the only look-back period on the books, in effect, let's put it that way, the only look-back period in effect right now in New York is a 5-year look-back for nursing home Medicaid benefits. That means if I needed a nursing home today and we applied for Medicaid, there would have to be a 5-year review of all my financial accounts, all my assets. They want to know, what have I tried to protect within the last 5 years? And if I did take an asset protection step within the last 5 years, they're going to penalize me and they're not going to pay for the care for a period of time. So when we talk about implementing an asset protection plan, an asset protection trust, you want to do it way in advance before the crisis occurs, okay? Especially for nursing home care, because there's that 5-year look back. Now you'll notice there, and I'll talk about this a little bit more later, I have 30 written there also when we talk about look back periods. So New York has a look back period on the books for home care, but it is not yet implemented. There is a 2.5-year or 30-month look back for home care. Again, I'll get into it more later. It is not yet, has not yet begun. Okay. So whenever we talk about asset protection trusts, we got to be aware of right now the 5-year and eventually the 2.5-year look back period. The next very significant point of an irrevocable trust is it has to be built in such a way that the assets inside are protected. And the way that we do that is we have to limit the grantor's access to the principal on the inside. So if we put a house and let's say $100,000 into this irrevocable asset protection trust, that trust must clearly say that the trustee cannot distribute any principal back to the grantors. Okay, that language is critical. We've actually seen irrevocable, quote unquote, irrevocable trusts from other attorneys that clients bring in here, and it doesn't have that language, or it actually specifically allows the principal to go to the client. That doesn't work. That is not a valid trust. That is not a valid irrevocable asset protection trust. So this rule is critical. Now, because this rule is so strong, we never put our clients' total assets into the irrevocable trust. There's always money left outside of the trust to live off of. In addition, there's always a back door as well. So the ability for money to come out of the trust can happen, but it has to go to the family or the grantor's other chosen beneficiaries. So we can get money out, just has to go around the grantors themselves. Okay. Now, the way these trusts are built, we can have it so that income can get paid out to the grantors if necessary. That's a conversation and an analysis as to whether it's appropriate. The trust will very clearly say that the client, the grantors, have the right to live there. They got the ability to sell, the ability to buy. Keeping control, they control the trustee. They get to decide who the trustee is. Let's say they pick their oldest child. They have the ability to fire that trustee, all right, and then appoint another or let the other child step up. So there's control there as to who the trustee is. Same thing with beneficiaries. So my folks have an irrevocable asset protection trust. That's not a surprise. And I have 2 brothers. So there's 3 children. I'm the trustee, probably not a surprise either. And what the beneficiary control means that the parents, my folks, can change the beneficiaries. They can disinherit me. They can disinherit my brother. They can change the inheritances up. That's all about control. That gives the client, that gives you the ability to change your mind about certain things. And again, when we're talking irrevocable, you want to have that peace of mind knowing that you're not out of the picture entirely. You can change the trustee. You can change the beneficiaries. You got the right to live there. You've got the ability to sell and buy something else. Okay? Something else that adds to the peace of mind is that this trust is what I call tax neutral. So taxes don't go up because of this trust. Real estate taxes, capital gains taxes, income taxes, they all remain the same. Now, they're not going down either, but they're not going up. So things remain the same. And ultimately, talk about peace of mind, even though it's an irrevocable trust, it can be revoked. All right. Not that we're going to want you to do that, but you need to know that there is always that larger, bigger escape hatch if necessary. Okay. So it is a very important tool. It is flexible where it needs to be flexible. And again, it's the gold standard when it comes to asset protection. I have had clients say, however, why can't I just give the house to my kids? Why can't I just give the $100,000 to my kids? Well, I call it the D's. All right. There's going to be a list here of things and words that begin with the letter D, and they're all reasons why you should not give everything outright to the children. Trusts serve a purpose. Now, that doesn't mean we don't make any gifts to the children. We do. And we sometimes have children hold money intentionally for the parents' benefit. But the house and the lion's share of the finances, they don't go to the children. Why? Because of the D's. They can die. They can become ill and have a disease. They can divorce. They can unfortunately perhaps have an addiction with drugs. They can have financial problems and debt. They can do something dishonest or dumb, and we all know they can do that. Or there could be increased taxes or duty, right? That's what they call it. So in keeping with the D's there, all of those risks that can happen to any of us, whoever's holding your money, if one of those things happen to that, whoever's owning your home, any of those things happen, that impacts you negatively. That's stressful. Not with the trust though. Okay. So the irrevocable trust protects against all of these things. Okay. All right. Next point. We're going to move on to the next domain. We just spent all that time talking about the legal domain and the planning and the protection that can be done to help you have that peace of mind. Now, the financial domain. As we've said, the financial domain is all about paying for the care. Remember the care, the long-term care? So how do we pay for the long-term care? There's 3 ways to pay for care, okay? That's it. I also said a little bit earlier, we're not talking about medical care. Doctors, hospitals, rehabilitation centers, those are medical needs. That's medical care, and that's covered by health insurance mostly. We're talking about long-term care, if you recall, which is the help with those activities of daily living and those instrumental activities of daily living. Only 3 ways to pay. Cash, out of pocket, usually done in the beginning, but not in the long term. Home care alone on Long Island, downstate New York, can be $1,000 a week up to about $2,500 a week. You could be looking at $10,000 a month for home care out of pocket. People aren't spending $100,000 for home care. The next way to pay, in nursing home care, double it. You're talking about $15,000 to $20,000 a month for nursing home care. It's a very expensive undertaking. Again, yes, it might happen in the beginning, but you can't pay $250,000 a year, all right, for nursing home care. Then, if we can't use cash or don't have the cash, some people have what's called long-term care insurance. It's a special health care policy based on age and based on your health. There's not a lot of those companies in New York left anymore. Why? Because the long-term care is so expensive, all right? If you have a policy already, that's great, but you have to realize that most of the long-term care insurance policies we see, while we're happy to see them, does not cover the full cost of care, okay? So if you have a long-term care insurance policy, it's good, but you got to get somebody to take a look at it or look at the costs of care and see if it actually will cover the care. If not, you and a lot of other people in New York are going to rely on what's called Medicaid, all right? So Medicaid can pay for long-term care. Medicare pays for your medical. So Medicare, medical, Medicaid, long-term care, all right? We spend a lot of our time during our days helping our clients plan, protect, and get the best care possible while getting Medicaid to pay for the care, okay? So what's next? The financial domain, pay for the care, and community Medicaid. I'm going to spend today talking about community Medicaid, not nursing home Medicaid. Nursing home Medicaid hasn't changed much. Community Medicaid is changing as we speak, all right? In addition, we want to be home, right? So let's spend some time talking about this. And I do have other webinars, as I said, on the website that talk about nursing home Medicaid, or you could always ask a question afterward or schedule a time to meet and talk about it more. Community Medicaid. How are we doing on time? All right, we got some more time. So what is community Medicaid? Well, community Medicaid is where a person is applying for Medicaid benefits in the community, in their home, or perhaps in assisted living. It's not in a facility. And the services that are provided are going to be a personal care aide, someone to assist with those activities of daily living, some case management, medical transportation, adult medical daycare, supplies for incontinence, for example, podiatry, audiology, and dental service as well. Eligibility. So Medicare, you hit 65, you've worked, you get it. Not so with Medicaid. You have to become eligible, if you're not eligible already, for Medicaid services. And there's 3 prongs to community-based Medicaid eligibility. It's going to be a person's assets, a person's income and it's their care needs. All right. 10 years ago, the care needs were an afterthought. It was all about the assets and income. But about 10 years ago, they've been focusing more and more about the care. It's why back in 2009, we started practicing life care planning. Life care planning is where we have on staff elder care coordinators. I have a registered nurse on staff, a geriatric social worker on staff. Why? Because families have concerns and because the care eligibility is so difficult to obtain and to prove and to maintain. Okay, so specifics. When we're talking about asset eligibility, $30,000, $30,182, that's a pretty big number. So the person applying for Medicaid can have that much. Income, $1,697. Again, higher. Numbers have almost doubled since last year as to what a Medicaid applicant / recipient can have and maintain. Now, in addition to the assets, those 30,000, a person can keep their retirement accounts. In addition to income, a person can keep any money they use to pay for health insurance benefits. So there's a lot of intricacies here. I certainly do not encourage you to try to undertake Medicaid eligibility or applications on your own. There's a lot of twists and turns, and we just don't know what we don't know. When we look at care eligibility, right now, it's mostly focused on the activities of daily living. Does the cognitive instrumental ADLs play a role? Yes, of course, but it's primarily attached to the physical functioning activities of daily living. Now, let's break these down a little bit. On the asset side, if I've got $100,000 in a house, how do I protect my assets? How do I become eligible? Well, as we've said earlier, there's no look back and there's no penalties as of now for home care Medicaid. So we can use irrevocable trusts and gifts to family as long as there's capacity. If there's no mental capacity, then we use that durable modified power of attorney I mentioned earlier in talking about the legal domain and the planning. Okay, so we gain asset eligibility with gifts to trusts or to family members. And again, for home care, no look back as of now. Now, the eligibility on the income side, well, what if I've got $2,500 in Social Security and a $1,000 pension? What we utilize very, very frequently is what is called a pooled supplemental needs trust. It's also called a pooled income trust. And that's the standard way in New York to shelter excess income. And again, I've got other webinars to talk about those details. It can get a little complicated, but we hold your hand through the entire process of joining the existing pooled income trust and using it properly, okay? The third point of community eligibility for Medicaid is, well, how do we get enough hours approved? Unfortunately, these days, Medicaid keeps cutting back the hours. So I'll tell people Medicaid is not the answer for home care. It's a big puzzle piece. It's a big part of the answer, but it's not the sole answer, okay? So how do we get the most hours possible? The way we do it is by having our experienced elder care coordinators advocate for your loved one during the several Medicaid assessments. There's going to be 3 to 4 different assessments that the state will conduct, 2 to 3 hours each on your loved one. Each of those assessments will have one of my advocates sitting next to your loved one advocating. Years, decades of experience my care coordinators have in the long-term care field. And they're there to make sure that the nurse from New York State or the nurse from what's called an MLTC sees all of the needs and awards the most hours possible, all right? How do they do that? Well, they're going to be proactively helping the family navigate, all right, the entire long-term care maze. They're going to be assisting with ongoing assessments. They're going to be coordinating the benefits and the providers with the family. If God forbid there's a crisis, they're intervening. I tell clients we sit with, mom's at home. If God forbid she's hospitalized and it gets transitioned over to a rehabilitation facility, you're going to let your elder care coordinator know, because then my social worker or nurse are talking to those social workers and nurses. They speak the same language. And the goal is to get mom home as soon as possible safely. All right. That all boils down to advocacy. So when you work with us, in these Medicaid circumstances, and again, what we call a life care plan, an elder care coordinator will be guiding and helping the family through. Now, I mentioned earlier that Medicaid, and I know I'm going fast, so forgive me. You could always get the download of this later tonight or tomorrow and go through it again. I mentioned the new Medicaid law. So there are changes coming to community-based Medicaid. Two changes. One is going to be a look-back period, and one is going to be harder care qualifications. And again, I'm grateful we have the advocates on staff to help the families through all this. The changes in particular, look back implementation, it is, as of today, it is scheduled to start April 1st of 2024. That means we have less than 1 year. If you or your loved one are in need of community-based Medicaid services, get the plan going now, because any applications filed after April 1 of 24 will be subject to the new 30-month look-back period, okay? Now, they might postpone it again, but they haven't said that yet. And they've been playing with this since 2020 when it all started, but they're doing it next year. They're gonna, I believe it'll be in effect next year. So we have, gratefully, a window of opportunity for community-based Medicaid applications without a look-back period until the end of March next year, okay? Other changes that are happening is the care implementation. They actually started, as I shared a moment ago, they're making the care part more difficult, more complicated, okay? And that started November of 2 years ago. So the care regulations that they've been doing and changing and again, making things more difficult for folks is there's now assessments done by independent assessors. The assessments are occurring hourly, which is why people stay with us year after year, because not only does Medicaid have to get reapplied for, recertified, but we also have to establish the need for hours. And there's been times in the past where the program has tried to reduce hours. You know, mom's getting 8 hours a day, and all of a sudden they come in and say, oh no, that's too much. Doesn't make sense. Mom doesn't get better over time. Generally, mom needs more help. So we need to fight to keep the hours we have or push for more hours, all right? There's now an independent practitioner medical order. So yeah, there's actually a doctor or a physician assistant involved with the assessments, making it more complicated. And then there was the idea of a high need or high hour case review panel. So this is still out there, meaning any cases over 12 hours a day, generally meaning 24/7, can get reviewed, and they can do it through a lens of safety. This is a complicated, sticky point, because if they're going to come back and say, my mom can't stay in her house because they don't think it's safe, who are they to say that? That's my mom, and she has her own independent autonomy to decide to get where she lives, to stay where she lives and wants to live. So this one gets sticky as far as what are they going to do if the state determines the person isn't safe in their home anymore? Well, you're going to need attorneys and advocates to help you navigate that. Another final change happening on the care side is the activities of daily living. So as of right now, we have to establish for the time being that your loved one needs assistance with at least 2 activities of daily living. The new law that'll be coming in next year, not only the look back, but they're going to be jumping this up to more than 2, which generally means 3. Several weeks ago, we had one of the directors from Suffolk County Medicaid as our guest on our senior advocacy forum. And again, that webinar is available on our site. And I said, well, 3 or more. And he goes, no, it says more than 2. And he's right. Jim was right. So ADLs, 2 or more ADLs will be required during the assessments, such as walking, bathing, and toileting. Again, all the more need for an experienced advocate sitting next to your side during these multiple assessments, all right, especially if they keep raising the bar. Now, a silver lining, if you will, to all the changes with community Medicaid. And as I shared also, it's mostly about the functional, not so much about the instrumental cognitive ADLs. This new law, as it rolls out, will finally account for Alzheimer's diagnosis or dementia diagnosis. So if there is a written diagnosis by the medical provider of Alzheimer's or dementia, we have to prove the diagnosis and supervision with at least more than 1 activity of daily living. So it's not the 2 and it's not the 3, and it's supervision. It's not the physical help. All right. So this is big. And we're still waiting for that to roll out. Now, third domain is the care domain. So we're going to keep going there because it's the care that's the driver. For years, before we started the life care model back in 2009, I've been doing this since 1998. And I sat with clients almost helpless for 5, 6 years before I started building a model and learning about how that we can address the care issues that families go through. I can't count the amount of children and spouses I've sat with through the 25 years where I'm here because my dad, my wife needs help. I have to protect the house. I've got to protect the income. I've got to get Medicaid to pay. Peel away the onion, peel away the layers. It's not so much about the house. It's not so much about the income. It's not so much about getting the care paid for. It's because your loved one needs help with their care. That's what starts the domino effect. So for us, making sure your loved one gets the best care is just as important as protecting the house. Okay. And honestly, this is, in my opinion, this is the future of elder law. If you're considering or have worked with elder law firms that don't address the care component, at least minimally, and there are a couple that do, then you need to find somebody that can, because the care issues are the driver of everything in dealing with elder care. Okay. So elder care. So care domain, how to help your loved ones get the best care. How do we do that? With our elder care coordinators. So the elder care coordinators, a whole host of duties, responsibilities, tasks, they truly enjoy helping families get the care that they deserve. They will go to not only the state assessments, but we do our own assessments. We'll coordinate the providers. We'll advocate throughout the entire elder care continuum, support the family, support the caregivers, help put into place a plan B in case something happens, intervene if there's a crisis. Ultimately, it's all about the peace of mind. It's all about the peace of mind. And the reason I'm combining this today to share that we want our clients to have that peace of mind is because you really need to undertake the protection and the planning before you get to the care, right? And we have clients that come here all the time where they don't do the planning and protection, and there's just so much to do at that point because it's all three. It's the planning, it's the protection, it's the Medicaid, it's the care. We want families to have peace of mind. So whether you're planning it in advance or it's a crisis, we want you to have that peace of mind. Now remember, you want to have that feeling of calm, of not being worried, a feeling of being safe and protected, calmness, tranquility, a freedom from worry and anxiety, not worrying about the elder care problem, not worrying about protecting the house. Let's get that taken care of. Okay, let's not worry about those things. Now, a typical elder law firm, as I was sharing a moment ago, is really going to focus on the legal and the financial matters. The care part, that's up to the family. Okay, I used to practice that way 14 years ago. But truly, the most helpful, the most comprehensive way to help a family is to wrap them up and help them with all three domains: the legal, the financial, and the care. All right, so you as the parent or the spouse, get the most help you can for your family as they go through this very difficult process. All right, that's why we're here. That's why we do these webinars, to share that we're here to help, we're here to talk, we're here to guide, and we're here to help you get that peace of mind. Now, timing. Do you do this in advance or do you wait to the crisis? The planning and protection, again, 65 and over, get your elder care protection plan in place. That's what we do. It's what we call an elder care protection plan. It's the irrevocable trust for the protection component. It's the last will and testament, the powers of attorney that are durable and modified, the healthcare proxies, and the living wills. And that comes with a whole year of service. I mean, questions, changes, funding meetings, as we call it, an annual meeting, an assessment from our care coordinators about the ADLs and the IADLs. That's all built into our elder care protection plan. Okay, 65 and older, get that done before the crisis. Now, many clients that we sit with don't get that done in advance, and we're dealing with the crisis. So the crisis, generally speaking, is when there is no planning and protection in place, and we have this significant need for care. I've been saying this for years. A crisis will always limit your options. A crisis will always be more stressful, and a crisis will always cost more. If you can avoid that crisis and plan in advance and be prepared, more choices, less stress, less money. That's how it works. All right. Think about driving on the LIE and the tire blows and you knew it was bald to begin with, or that battery light's been going on. Would you rather have that battery taken care of before the crisis or when you're driving on the LIE at 11 o'clock at night? Right? You get what I'm saying. Avoid the crisis, shoot for that peace of mind. This is within your control. Okay. So when should you start? 65 and over, get that elder care protection plan in place. If the activities of daily living, if your loved one is starting to decline functionally, cognitively, maybe it's time to discuss the need for a life care plan. Do not wait until that crisis hits. Okay. Again, I'm Brian Tully. Thank you for joining us. I'm the founder of Tully Law Group, certified elder law attorney. We specialize in elder care issues and estate planning issues. Tully Elder Law, Tully, elderlaw.com. Our phone number, 424-2800, 631-424-2800. We're here to help. Please let us do so. All right. Let's see if we have any questions. I got a little bit more time. This actually went a little long today. Question, would both the husband and wife be the grantors, or just the wife be a grantor of an irrevocable trust if only applying for the husband and all the assets in the house are under the wife's name? Great point. All right. So Dina asked that question. Generally speaking, 65 and over, planning in advance, implementing an elder care protection plan, both mom and dad are healthy, both are grantors. If we're in the crisis, things change. So that's what your question points out, and you're right. If we're looking at a crisis, maybe just one spouse is going to be the grantor of that trust, 100%. And the beauty of the way we do it, folks, I got a team over here that's second to none. We've got a team of 23 people, from the attorneys that run the Medicaid department to the planning department, between the partners, the senior associates, the associates, our paralegals, fantastic, helpful paralegals. Our team comes up with the plan with you, and we'll be able to address all those concerns together. Okay. Another question, is a lump sum withdrawal of a Roth IRA considered income from Medicaid in the entire year, or just the month you take the withdrawal? So as I shared before, looking at the asset eligibility for Medicaid, you're allowed your $30,000 and you're allowed to keep your IRAs, including Roth. The only way that you're able to keep them is because you're over perhaps 73 years of age, 72 years of age if you're older, and you're taking your annual distributions on your traditional IRA or 401k. If it's a Roth, you start the distributions as if it was a traditional IRA, and then that Roth will also be exempt, okay? It is considered income in the month it's received, and it's considered an asset the month after, all right? With an irrevocable trust, please re-explain tax neutral. So it's not a technical term. It's just a phrase that I've coined, meaning it's neutral. It doesn't change things positive or negative. For example, your real estate taxes. If the home is in an irrevocable Medicaid asset protection trust, you have the right to live in that house. Because the right to live exists, your real estate tax exemptions remain. So the real estate taxes aren't going up and they're not going down. Is that a general statement? Yes, but that's what we see 99% of the time. Another example is income tax. If there's income generated in that trust, the parent is claiming that income on their personal tax return, just as if that income was in their name, that account was in their name. Again, taxes aren't going up, taxes aren't going down. Can I take money out of an IRA and give it to children? Of course you can, Ed. Just you have the income tax bite. All right. So that's a financial advisor question, primarily a CPA question to gauge what the tax would be. Is that an exempt transfer? You didn't ask that, but the answer is no. It's still a gift from you, subject to penalties and look back period concerns. And so there. With an irrevocable trust, does the trustee have the right to sell a piece of property within the trust that the grantor is not living in without the grantor's consent? Good question. So the way our trusts are drafted is that the grantor has the right to reside in any of the properties owned by the trust. And any purchaser that's doing it the right way, which is all of them, is going to obtain a lawyer in New York and a title company. They're going to need to see the copy of that trust because that's the owning document, the owning vehicle. And in that trust, they're going to review it. The legal department's going to review it. It's going to say, Mr. Smith has the right to reside in that property you're selling. So they're going to need Mr. Smith to sign off and extinguish his right to reside. So that's how the parent gets brought back in. If there is a way that that happens without that occurring, then the grantor has the ability to fire the trustee and to disinherit them. Okay, so again, all ultimate control goes back to the grantor with the trustee. Will the beneficiaries get a basis step up in the house if it's in an irrevocable trust? Ed, the answer is yes. It's part of that tax neutral discussion. So capital gains taxes are again neutral, meaning if you have a primary residence and you sell that primary residence after living there for 2 of the last 5 years, you have an exclusion of capital gains taxes of $250,000 per owner. You keep that with the trust. And yes, to answer specifically, the children, the beneficiaries, will get the step up in basis after the grantors pass. For community Medicaid, eligibility, assets, qualification is the 30,000. Please explain which assets. Lori, it's everything, all right, except the IRAs and retirement accounts. It's checking, savings, annuities, non-qualified annuities, cash value and life insurance, stocks, bonds, all right. What's excluded is going to be, gets tricky, what's excluded is those IRAs like we've spoken about, and the primary residence the person is living in. Even though the primary residence the person is living in is exempt for eligibility purposes, you never want that house in the applicant's name because there are certain risks with Medicaid. And by the way, if you go to our website, tullyelderlaw.com, scroll down, you can download our Planning for Aging guide. All right. And it talks about the elder care protection plan. It talks about the life care plan. It talks about the risks with Medicaid that I'm bringing up right now with Lori. And if you keep that house in your name, what you're doing is it's going to be a part of your estate when you pass away because it's not protected. It's not in a trust. And then Medicaid goes after it. Okay. So all financial accounts you could think of, except qualified retirement money, you're allowed to keep the house, but you don't want the house. Is an annuity transfer into an irrevocable trust non-taxable? So if it's a non-qualified annuity, we can usually have that transferred into our irrevocable trusts because they're called grantor trusts. Does it happen all the time? No, it's a case-by-case situation, but it usually happens where it's not a taxable event. What are the conditions for eligibility to transition from community Medicaid to nursing home care if my mother needs to go to a nursing home? So most folks want to stay home, but sometimes a nursing home is necessary and appropriate. There's 3 times when a nursing home becomes necessary and appropriate. The first one is when we have a situation that's become too medical, when it's a perfect storm of medical concerns that are just too much liability or not able to be maintained safely in the home. That's where a nursing home may become appropriate. Another place where a nursing home may become appropriate is behaviors. So if your loved one is demonstrating behaviors that are not safe for themselves or for the aide or for the family, violence, aggressiveness, throwing things, the agency is not going to keep their aide in a home that's not safe. So you talk nursing home. The third time where a nursing home becomes appropriate is when you don't have a plan B, when your caregiver burns out. It could be a spouse, it could be a child. If somebody is not availing themselves of private paid long-term care or Medicaid paid long-term care, you don't have a plan B in place. If you're relying purely on a spouse or children to provide the care, you don't have a plan B, and burnout is real. And if that happens, now you're talking nursing home. Okay. Now, financially, all right, what you're looking at is the same $30,000, but you have the 5-year look back to contend with. Asset-wise, income-wise, you got $50 a month plus health insurance premiums. Everything else goes to the nursing home. And then on the care side, you don't have all those assessments. Rather, you have what's called a PRI, which is a patient review instrument. So that is prepared by a nurse, gives a score for the admissions office to look at. Plenty of advocacy still required at the care planning meetings, but that's in a nutshell the eligibility for nursing home. All right. So if you withdraw all the Roth IRA at once, it's not income. No, it's entirely, no, Roth IRA, no, it's already been taxed. A Roth IRA, Mr. Anonymous, is already taxed. It's post-tax dollars. So if you pull all of that out, you're not going to be taxed. But again, I'm not a CPA, so feel free to ask your accountant and get a definitive answer from the person that would actually file your tax returns. But Roth IRAs are post-tax. Last question. I have power of attorney from 2014. Powers of attorney, as I've shared, probably the most important planning document there is. If it's not modified, it's not worth the paper that it's written on. New York State has made this very complicated. They've changed the law 3 times, 2009, 2010, and 2 years ago in 2021. If you have a proper modified durable power of attorney from 2014, it's still valid. We could take a look at it. Maybe you want to implement the new one because it was meant to be easier to implement and understand. But the new law from 21 does not void out the old one. And as long as you've got the right modifications built into it, you're going to be fine. Okay. I am out of time. I've got a consult starting right now, so I apologize. Thank you for joining us today. Be on the lookout through our email. Get on our email list, download the guidebook. You automatically get onto our email list, and then you'll be notified of the next. Or check out our social media. Facebook always has our posts, LinkedIn as well, Tully Law Group for Facebook and LinkedIn. All right, thank you again. Be well and do what you can to get that piece or keep that piece. All right, bye.